From risk to protection, why E&O is essential. As we move forward from standard of care and legal exposure, we now focus on one of the most critical protections available to brokers and agents: errors and omissions, E&O insurance. At this point in the course, you should clearly understand that lawsuits, complaints, and claims are not a matter of if, but when. E&O insurance is what stands between a professional mistake, or even an unfounded allegation, and financial disaster. This section ties directly back to supervision, documentation, and risk management. E&O is not a replacement for compliance. It is the safety net when compliance fails. The reality of risk in real estate practice. Real estate is considered a high-risk profession due to the complexity of transactions, large financial stakes, and reliance on professional judgment. Even when a licensee acts correctly, claims can still arise. The reality is that defending a claim, regardless of fault, can be financially devastating. Legal fees, expert witnesses, depositions, and court costs can quickly escalate. This reinforces a key concept. You do not need to be wrong to be sued. What E&O insurance covers: defense and protection. E&O insurance is designed to cover legal defense costs and potential settlements or judgments arising from professional activities. In many policies, defense costs are covered either in addition to or within the policy limits. This distinction is critical, as a prolonged legal defense can reduce the amount available for settlement. The takeaway is simple: understand your policy before you need it. The financial reality: winning can still cost you. One of the most misunderstood aspects of litigation is that even if a licensee wins a case, they may still suffer significant financial loss. Unlike some legal areas, the losing party in real estate litigation does not always pay the prevailing party's attorney fees. This means a licensee can win the case but still incur tens of thousands of dollars in legal expenses. This is why E&O insurance is not optional. It is essential. Broker Policy Manual. The first line of defense, under AAC R428-1103, brokers are required to maintain policies and procedures that guide their business practices. An effective policy manual not only ensures consistency, but also provides legal protection. If a licensee violates clearly established brokerage policies, the broker may have a stronger defense against liability. This reinforces a critical connection. Strong policies reduce claims and strengthen defenses. Reporting violations. Protection for brokers. Arizona law provides some protection for brokers who proactively report violations by their licensees. Under AAC R428-1101F, the ADRE may not take administrative action against a broker who reports misconduct. While this does not eliminate civil liability, it can strengthen the broker's position in both administrative and legal proceedings. This ties directly into supervision. Ignoring problems increases risk, addressing them reduces it. When policies are not required, limited exception. There is a narrow exception under AAC R428-1101G for very small brokerages with minimal staff. However, even if not required, having written policies is still considered best practice. In today's regulatory environment, operating without clear policies is a significant risk. Common causes of E&O claims. Most E&O claims arise from predictable issues, including failure to disclose material facts, negligence in property evaluation, breach of fiduciary duty, and contract errors. Other common causes include misrepresentation, agency disputes, and compliance violations related to federal and state laws. This reinforces a consistent theme throughout the course. Most claims are preventable with proper systems and supervision. Statistics: the likelihood of a claim. Studies show that a significant percentage of real estate transactions involve E&O claims, particularly in residential brokerage. This highlights an important reality. Real estate professionals are more likely to face a professional claim than many other types of risk. This is why E&O insurance should be viewed as a standard business expense, not an optional add-on. ADRE reporting requirements. When claims become public, Arizona licensees are required to report adverse civil judgments to the ADRE within 10 days. Additionally, the ADRE may initiate its own investigation regardless of the outcome of a civil case. This means that even a successful defense in court does not eliminate regulatory risk. This reinforces a critical point. Legal success does not guarantee regulatory protection. Real-world example: the cost of being uninsured. Consider an agent who is sued for failure to disclose a material defect. Even if the claim is unfounded, the cost of defending the case could exceed $50,000. Without E&O insurance, the agent must pay these costs personally. If the case results in a judgment, the financial impact could be catastrophic. This example reinforces the ultimate takeaway. E&O insurance protects your business, your finances, and your future. How this section connects forward. This section ties together everything we have discussed: standard of care, supervision, documentation, and legal exposure. E&O insurance is the final layer of protection in a well-managed brokerage. As we move into the final sections, we will focus on integrating all of these elements into a complete risk management strategy. The goal is not just to react to problems, but to prevent them. The message is clear: compliance prevents claims, but E&O protects you when claims happen. Online discussion question 1. Why is E&O insurance essential for real estate professionals? Answer: because it covers legal defense costs and potential damages, protecting licensees from financial loss even if they are not at fault. Question 2. Does winning a lawsuit eliminate financial risk? Answer: no, because legal fees and costs may still be incurred even if the licensee prevails. Question 3. What is the relationship between supervision and E&O claims? Answer: strong supervision and policies reduce the likelihood of claims, while poor supervision increases risk and exposure.